The Economic and Financial Crimes Commission, EFCC, last week declared Yahaya Bello, the immediate past Kogi State Governor, wanted in connection with an alleged laundering of 80.2 billion naira. This comes as the anti-graft agency disclosed at the Federal High Court in Abuja that it will use relevant state powers to ensure that he is arrested and made to stand trial. Arise correspondent Godfrey Eshemoye has more.
In fulfillment.
Yahaya Bello is a man on the run, with the EFCC hot on his trail with a 19-count charge bordering on money laundering filed against him. With his whereabouts unknown, his case came up on Thursday at the Federal High Court Abuja before Emeka Nwite, the same trial judge who 24 hours earlier granted a warrant for his arrest. Abdul Wahab Mohammed, who represented Mr. Bello in court when the matter was called for his arraignment, challenged the validity of the charge on the ground that the court lacks jurisdiction. The senior lawyer who urged the court to vacate the arrest warrant said a high court of Kogi had on February 9 restrained the anti-graft agency from arresting, detaining or prosecuting Bello. Bello's counsel also objected to the application by EFCC's counsel, Kemi Pinero, to serve him the charge on his client's behalf, as it's a criminal trial. However, Pinero argued that Bello, with the aid of his counsel, seemed to be on a quest to frustrate the trial by evading service of charge. The prosecutor therefore says the anti-graft agency will go all out to arrest Yahaya Bello ahead of the April 23 date fixed by the trial judge to rule on the mode of service.
We have informed the court that by virtue of Section 287 of the Constitution, all persons are obliged to obey the court order. The court order is for his production on the next adjourned date, and the state will ensure that it's produced in court. Section 12 of AJA also allows a law enforcement agent to break down any premises where a defendant may be hiding. And so the state will invoke all its powers within the law to ensure that it's produced in court for the purpose of arraignment, and it's in his own interest. So he can come and plead his innocence or take his plea as to whatever he wants to say.
Meanwhile, the EFCC has released wanted posters of Yahaya Bello. The former Kogi State Governor evaded arrest at his Wuse home after the Kogi State Governor, Usman Ododo, and the company of police operatives allegedly whisked him away to a destination unknown, giving another twist to the unfolding drama. Godfrey Eshemoye, Arise News.
Meanwhile, hundreds of human rights activists hit the streets of Lagos to condemn what they described as the Economic and Financial Crimes Commission's anti-democratic approaches to issues of law enforcement, as well as unjust application of state power by the federal government. Joining us now is Frank Tietie, a lawyer, convener of Food Avail Nigeria, and executive director, Citizens Advocacy for Social and Economic Rights. Good morning and welcome to the morning show.
Good morning, and always my pleasure.
Good morning, Frank. Good to have you on the morning show. Very quickly, I mean, the story of EFCC versus Alhaji Yahaya Bello is very well known. There are many aspects to it: legal, operational, political, and all of that. Just give us your own take on the various dimensions and what you think is likely to happen next.
Oh, well, thank you very much. Thank you very much. The issues are clear. The Kogi State High Court has actually made the issues clearer when it declared that Yahaya Bello is being witch hunted. In its words, it said the EFCC has carried on a misfeasance and a malfeasance. That is, there is an unjust application of its wide and enormous powers against Yahaya Bello in a bid to persecute him, in a bid to do the whims and caprices of his political enemies. So it is sad that when an agency of government that has such kind of powers does not actually play in such a manner that it can command the integrity and respect of even accused persons. The Yahaya Bello didn't say so. It was the court that agreed with him and gave such a ruling that he shouldn't be arrested and he shouldn't be unnecessarily embarrassed. The court was very clear that he could not grant an order preventing a statutory body like the EFCC from carrying on its job, its prosecutorial or investigative job. However, the history of his dealings with Alhaji Yahaya Bello showed that it was carrying on an agenda of untruth, of media trial, of an attempt to deprive him of his right to fair hearing and of his right to liberty. Yahaya Bello was able to convince the court, both at the ex parte level and ultimately at the judgment, at the ultimate judgment, that the EFCC was not conducting itself properly according to the tenets of criminal prosecution. It gave an order that if at all it considers that it must prosecute Yahaya Bello, it should first of all approach any court, particularly the Federal High Court or any other court, to obtain leave, having been satisfied that its conduct, that is the conduct of the EFCC, is actually below expectation. So this is more political. It's even contravenes the fact that, because if you look at Section 42 of the Constitution, it talks about freedom from discrimination. So when you consider that Yahaya Bello is saying that he is a target of a political persecution, you will now realize that some other persons who have the same problem that he had, one of them who actually directly simply, got a very smart tactics of accusing the EFCC first before accusing him, actually put the EFCC on the run. And today he's a minister of the Federal Republic of Nigeria, and the EFCC is afraid of him because what the EFCC is trying to do is to bring a contestation and a contest of force, abusing its force, having convinced itself that it has made mistakes in the way it has approached Yahaya Bello's ordeal by filing false statements against him, even when Yahaya Bello, these are statements that are contained in the affidavits that were before the court. The EFCC didn't conduct itself properly. In that case, it's important that Yahaya Bello will fully exhaust all of the remedies available to him in the Constitution. Many Nigerians do not know that Section 46 of the Constitution grants the Chief Justice of Nigeria the powers to make rules as to fundamental rights enforcement procedure. And in the hierarchy of laws in our country, the Constitution is supreme. And then if you must look at other statutes, according to the court, the fundamental rights enforcement procedure rules are actually next. And those rules declare that if you perceive that your rights will be violated, they don't have to be violated first. If you perceive that you're about to be hounded and arrested and go through an ordeal of a trial without facts.
Go ahead. Frank?
Yes. If you perceive that your rights will be violated, they don't have to be violated. Just what Section 46 will say is that once you perceive that your rights will be violated, you can approach the court for any form of protection. It is very difficult to fault what the judgment in Kogi has made. And the EFCC is trying to use force to cover up its mistake concerning the way it has blown that opportunity it had.
All right, blown opportunity again. This is not the first time, and perhaps might not be the last time the EFCC would conduct itself or be accused of conducting itself in a very unprofessional manner. How do we move forward from this? Because the truth is that it has cost the EFCC, and I dare say Nigerians, a lot of high-profile, maybe convictions. You cited the example earlier on and many others. And so what we then have is a drama, and then it just ends at being a drama. Usually, or sometimes, because of the fact that the EFCC have not conducted themselves in a professional manner. How do we begin to contain this? What are procedures, processes, or things that have to be put in place to ensure that we're able to have a more professional agency that would hopefully lead to more convictions where the personalities are found guilty?
First, the EFCC must understand that it works for the Nigerian state, though It's under the control of the government. The EFCC and its operatives and its officials must stop thinking that they possess one kind of force that is above the law. And again, they shouldn't conduct themselves with this air of being enemies. I overheard the lawyer talking as if they are enemies of Yahaya Bello. They should go back to basics of prosecution. You are an officer of the state, and your duty, the state is also interested in anybody who is a suspect or an accused person. And the overall goal of the Administration of Criminal Justice Act is to ensure that the rights of a suspect are actually protected. So the EFCC must now begin to, first of all, position itself to obtain that kind of integrity by being civilized. And then realizing that it is first of all under a civil authority. And then it can now also engender that, confidence, even among suspects and accused persons, that it is out there to do justice and not there to do the bidding of political enemies, or in this case, the political enemies of Yahaya Bello. Yahaya Bello perceived it, that even while he was governor, he saw all of those, those media attacks and those threats. In fact, there was one particular piece of information that was contained, affidavit that was contained in that affidavit, wherein he was advised by a certain official of the EFCC to go and have a meeting with the EFCC chairman for the bid of settlement. These are very unprofessional. You see, the EFCC must learn that it is working for Nigerians. It is not against the person that he wants to send to convict. In fact, the goal of criminal prosecution is not necessarily to convict and to sentence. Now, imagine the huge embarrassment for a country, for a state that is supposed to protect the rights of its citizens. You must appreciate that the system, even the judicial system, the administrative system, Nigeria as a whole, actually has a bias for the protection of individual rights. But you can imagine someone like Bello Adoke, who was subjected to 9 years of trial, with spurious allegations, and the man was shouting all through those years that I did not do any of those things. I was acting on a direct presidential order. Nobody listened to him. The FCC turned a deaf ear to that, and made the man and destroyed nearly 10 years of that man's life. Nobody will subject himself to that kind of, when you see that kind of danger coming your way, in the way Yahaya Bello sees it, in the way that they have conducted themselves, and then will not take action. And many Nigerians don't know that our country, when they say fundamental rights, meaning that those are rights that are equated with the existence of Nigeria. You don't play with those rights, especially the right to fair hearing, the right to life, and the right to liberty. You don't deprive a person. You don't just go and arrest when on the grounds that you don't like the person, you hate him, whether or not you like him or you hate him. Just simply follow the law, create the impression. So I go back in one sentence. EFCC must operate as if it is working for the Nigerian state and not for the Nigerian government or for political enemies of Yahaya Bello.
Okay. His rights must be upheld. The law is the law. I will get that argument. I know a lot of people have also said many things about Yahaya Bello at this point in time. They've talked about how he too denied political opponents this right in the state. They talked about election cycles and what happened and all of that. We remember the case of Natasha Akbuti, how she was dragged around while only offense was running against Yahaya Bello. We've seen how he too denied rights, but the rights must be upheld, and the law is the law. I would like to ask you, why then, as a law-abiding citizen, cannot Yahaya Bello not go ahead and meet up with the EFCC for this invitation before they pan it out in court?
I just told you the reason.
Why all of this?
I just cited the example.
I'm saying this. You cited the example of Adoke. We got the example of Adoke. But as a law-abiding citizen, other people too have been invited and they went. The case of Aguloye is there. Aguloye went, he honored them as a former minister. It was a case of something that had even been long in the past. So why can't he just go ahead and honor them and stop all of this drama and all of this brouhaha? I know your point is, political consideration, so he preempted them before now and all of that. But why can't he just go ahead and honor them? Why this brouhaha that somebody had to come and save him in his house, and there were allegations of a sitting governor driving in and things like that? If you've got nothing to hide, why don't you just go ahead and face whatever you want to face in the EFCC? That's what a lot of people are asking.
I wish I was Governor Yahaya Bello's, former Governor Yahaya Bello's spokesman. I think I would have been properly briefed on that. I wouldn't speak for him. I don't know the reason why. But I speak as a lawyer whose career in the last 15 years has actually been more in the practice of fundamental rights enforcement. And I can tell you why there is that kind of apprehension. You know, there can't be a better example than that of Bello Aduke. And the Supreme Court has held that nobody should be put through the ordeal of a trial on, you know, on flimsy and, you know, vexatious grounds. That's the reason why for you to proceed to trial, there must be, to a large extent, that prima facie case that has been established against the person. That is, there is some likelihood, a strong likelihood that of conviction, of substantial facts that can actually ground a conviction. But in this case, let me tell you what I think is the real problem. And I rely on the judgment of the Kogi State High Court. That is, the conduct, the proceeding, this arrest, the conduct is what holds the EFCC deficient in terms of integrity. And it is what also exposes the fact that the Yahaya Bello as an individual needs protection. Let me tell you, the courts are not Father Christmas. It's only when you approach them and ask for, by way of application, and ask for for a relief that they can give to you. I understand the wide and many dimensions of violations of human rights of ordinary citizens. Unfortunately, the legal aid hardly comes to them. That's why I ran for a long time, for a very long time, I believe more than 10 years, a pro bono practice, granting free legal representation, especially to persons whose rights were violated. But because I know that's a problem. But for those persons who have smart lawyers, they will always exploit the provisions of the Constitution. And let me tell you something. The prosperity of a country lies on the fact that it is a law-abiding country, and its institutions define whether or not it is going to be a country that will have citizens that have a good standard of living. That is a theory that Daron Acemoglu and Robinson, in their book, Why Nations Fail, in comparison between the United States and its neighboring Mexico, why the United States is so prosperous and Mexico is struggling. The simple reason why countries progress is because institutions subject themselves in a republic to law. Now, let us understand this. I have a passion for this country to be great, and for it to be as great as the United States is for us to play around everything. All authorities and persons must be subject to law, and not only law, the legal process.
Yeah, those are fundamental principles. But let me raise the point that indeed Alhaji Yahaya Bello had gone to court for the enforcement of his rights, and EFCC went to court, and in fact today, April 22, a court of appeal, is taking up the matter. But the EFCC went ahead, of the court or of the matter that is to be decided today. That's one of the things that commentators on the subject have brought up. However, what do you think of the complicity of the judiciary? Because, look, one case after the other, the EFCC going from one court to the other, and courts granting ex parte order, interim order, and all of that. I mean, the issue is, do you think that the courts, the judiciary, has been complicit in the mess that you tried to describe?
Not at all. Not at all. You need to understand, and again, I can't emphasize this enough. The judge is an unbiased, impartial, independent umpire. It is what you present before him that he pronounces upon. This idea of forum shopping has been deprecated several times by the Supreme Court. It happened in the case of this same EFCC versus James Ibori, when James Ibori was accused of Governor James Ibori, as he then was governor of Delta State, was accused of tampering with funds belonging to Delta State. He was taken all the way from Delta State to Kaduna for trial, and you needed to see the political upheaval of where his loyalists, got into convoys headed from Warri straight to Kaduna just to, solidarize with him. And now, this whole sensationalism of corruption trials must stop, and the Supreme Court has
you don't seem to get the point I'm making.
Now, it's on.
Can you hold on? I'm talking about a situation whereby courts of coordinate jurisdiction will seem to appear to be acting like appellate courts over each other. That's what I'm talking about.
Thank you very much. I didn't get that point. But you see, I also do not hold the judiciary to be deficient here. I can tell you this. I have been a lawyer prosecuting a senior advocate for misleading a court at the Legal Practitioners Privileges Committee. The idea is that we lawyers are the ones who oftentimes mislead the court. And if you look at this case of Yahaya Bello now, you find that there was certain suppression of facts before the Federal High Court in Abuja. And again, because I can tell you, no judge who has the basic or the minimum, understanding of judicial ethics will dare to go against the judgment of another court or an order of another court of coordinate jurisdiction. If the Federal High Court in Abuja was sufficiently made to understand that there is a subsisting judgment of a Kogi State High Court demanding and directing the way and manner that Yahaya Bello should be treated concerning his, specifically barring arrest, barring all forms of any form of embarrassment, and ensuring that his rights are upheld, that judge would not have granted that warrant of arrest. So oftentimes, we lawyers are the ones, because we are just desperate to win cases, forgetting that we are simply ministers in the temple of justice. We are accessories. We simply help the court to achieve justice. We don't lie. We say the fact the way it is. In fact, we have obligation. In fact, starting with the prosecutor, he has an obligation to even cite a law, even when it's against him, just because he needs to bring it to the attention of the court so that you can achieve justice. It is not about we and against them. It's about a state that is operating according to law. It has been a long journey, but we will continue on this path of saying, look, we can only achieve that El Dorado in one way or the other one day when we use the instrumentality of law, and the legal process with honor, not with malfeasance, not with malice. Because what has become clear is that the EFCC is carrying on a malicious prosecution against Yahaya Bello, and it has often done that. That can be attributed. Yes.
All right. Well, Mr. Tietie, I think you've made your point very clear this morning, and thank you so much for your time. Always good to have you on the morning show.